All rise.
Hearing the appeal of Norris against the government of the United States of America and another.
I think it'd be better if you, press the button so we can hear what you're saying.
It would be better if you moved your lectern a little to one side and gave your... Yes. But if you were closer to that side, you would...
I think you may be at risk of masking the microphone. I think, yes. There we are.
The one thing you must not suppose is that that has any effect at this end of the court. It has none. So you will need to speak up. It is a cavernous space.
In that case, I think it is not there. The United States. The court has given liberty to intervene to liberty, who are represented by Mr. Hermer, Mr. Middleton, and Mr. Gask. Some things are common ground on this appeal. It is common ground that the extradition of Ian Norris to the United States to stand trial for obstructing justice would engage the Article 8 rights of both Ian Norris and his wife Sheila. The United States accepts that and always has done. For our part, we have always accepted that in principle the extradition of accused persons to countries with bilateral treaties with the United Kingdom serves an important extradition is capable of the right facts of being justified by Article 8.2. The question on the appeal is therefore entirely a question of proportionality. Is it necessary, in order to vindicate the public interest in the prevention of crime, to extradite to the United States to face trial on this charge a 66-year-old man in extremely poor since 2002, in the declining years of his own life and his wife's. Now, I put the question as one of necessity, because it will be my submission that necessity is an essential part of the legal test accepted by long-standing Strasbourg authority, which I will come to in due course. But the problem about the individual courts' approach, as I will submit, is that they have approached the whole issue at too high of generality. They have set about balancing the value of honouring extradition treaties as a general principle against the value of the private and family life of accused persons. Believing, as they did, that the honouring of extradition treaties was the weightier principle, they concluded that it was bound in practice to prevail unless there was something remarkable about Mr. Norris's case as compared with the generality of other cases. In fact, in our submission, the inquiry is a great deal more fact-specific than that. What they should have done is to ask what harm it would do to the public interest in the prevention of crime. In this particular instance, not to extradite Ian Norris, and to consider whether extraditing him with all that is a flat and fly for him and his wife, in the circumstances of this case, is really a proportionate response to that harm.
Is there any concept of reciprocity here? Because one of the features of dealing with another country in extradition matters is that one would expect to be treated by that other country in the same way as we treat them. Is there anything of that in this case, in view of the nature of the treaty?
It's very difficult to bring reciprocity into it. First of all, although, of course, the United States has its own Bill of Rights, it is in terms very different from those of the Human Rights Convention that prevails as a matter of statute here. It's also difficult to bring reciprocity into it because the whole basis of extradition law in the United Kingdom since 2003 has to a large extent abandoned the reciprocity that was characteristic of it before. The principal example of that is the requirement to establish a prima facie case. The Secretary of State to designate countries in relation to whom no prima facie case will be required before a person is extradited to them, and has done so in the case of the United States. The position, as we understand it in the United States, by comparison, is that the Fourth Amendment of the US Constitution prohibits the detention of persons on warrants without probable cause, or precise phrases, but at any rate, it has been held at any rate at Federal Circuit Court of Appeals level that the effect of the Fourth Amendment is to prohibit extradition warrants without the showing of a prima facie case. So that reciprocity is not a significant feature of extradition law in the United Kingdom as matters stand.
As where the United States is concerned, it's not a general proposition. If you're looking at a European arrest warrant, although one no longer has to go into the merits, that's a reciprocal test.
The European arrest warrant is a wholly uniform system which has involved really quite significant changes in the domestic law of a number of European countries, more significant, as a matter of fact, than those their statute law to permit the extradition of nationals. There are other examples.
The recital to the US-UK treaty says desiring to provide for more effective cooperation between the two states is obviously an element of reciprocity.
Well, cooperation is undoubtedly a critical element, but the cooperation is not in all respects on a reciprocal basis. I would be the first to accept that in some respects it is. The treaty has had the effect of removing obstacles, some obstacles to the path of extradition in both jurisdictions, but it hasn't done so on a reciprocal basis. It is common ground that it is no part of the legal test that exceptional circumstances must be found before extradition can be refused on Article 8 grounds. The decision of the House of Lords in Clang and the Home Secretary, to which I shall come at a later stage of my submissions, is authority for that proposition. There is a certain amount of debate, both in the English case law since Clang and in the written submissions before this court, about the circumstances, about the differences between requiring exceptional circumstances to be shown as part of the legal test and simply recognising that in practice the balance will come down in favour of extradition in the great majority of cases. Now, in our submission, that is a sterile debate about a distinction that has very little real meaning. It is one thing to look back in hindsight at a string of cases in which accused persons have sought to resist extradition or deportation, Article 8 grounds, and then to observe that the great majority of them fail. It is a very different thing to do what the divisional court did here, and to allow the fact that most such cases fail to inform a particular decision. The latter approach inevitably leads to a particular attitude to the facts, which runs, roughly speaking, as follows. Most of these cases fail. What's special about this one? Straight away, in that formulation, you have the concept of exceptionality removed from the legal test, but reintroduced as part of the process of analysing the facts. And that is in our submission of what happened here. If your lordships and my lady would take the court on terms of the court, the essence of the reasoning. Paragraph 21, laws observe, in my judgment, the learning here and in Strasbourg shows that the public interest in giving effect to bilateral extradition arrangements possesses especially pressing force because of its potency, A, in the fight against increasingly globalized crime, B, in the denial of safe havens for criminals, and C, in the general benefits of concrete cooperation between states in an important common cause. The gravity of the particular extradition crime may affect the weight to be attached to these factors, but because they are of a strategic or overarching nature, the public interest in extradition will always be very substantial. Accordingly, the claim of a prospective extraditee to resist his extradition on Article 8 grounds must, if it is to succeed, possess still greater force. That is why there must be striking and unusual facts, JSO, or in practice a high threshold has to be reached, TAGI. That is how the balance between the public interest and the individual right inherent in the whole of the Convention is to be struck, where an Article 8 claim is related to the extradition case. Their lordships in Wang disapproves the application of a test for exceptionality as the means of striking the balance, although it is perhaps not without interest that the European Commission of Human Rights stated in Malta in the United Kingdom circumstances the extradition of a person to face trial charged with serious offences committed in the requesting state would be held to be unjustified and disproportionate to purpose with the right to respect the family life. The formulations in JSO and TAGI show that what was sought incorrectly to be gathered in the test of exceptionality is correctly reflected in a recognition of the force of the public interest in giving effect to a properly founded extradition request. A recognition, that is to say, of the relevant Article 8.2 considerations, which, in my judgment, find concrete form in the free public benefits I set out in paragraph 21. This is, with respect, the point made by the Justice Lord Iran, which strokes that pain against person of justice is a case which I should be coming to in due course, perhaps that will be not read from the judgment of the Divisional Court. Now, those paragraphs, as I have suggested, express the essence of the Divisional Court's reasoning, and I would suggest that two things are clear from it. First of all, the Divisional Court is asking what is the importance of honouring extradition treaties generally, and not what harm would be done to that principle by not extraditing a man in particular circumstances, as Norris's case. Secondly, the exceptionality test is simply reappearing in these paragraphs as a tool of factual analysis and under a very slightly altered rubric, but the substance of it is the same. That was presumably because the Divisional Court recognised that this might be said, as against their approach, that it certified the point of law in the terms that it did. Now, in our submission, the approach that the Divisional Court took is mistaken. It has led both district judges and the Divisional Court to deal with these matters in a way which sets the bar so high that in practice extradition requests cannot be refused on Article 8 because of what Lord Justice Laws call strategic or overarching requirements of extradition treaties. I propose, if I may, to deal with the material in the following order. I want, first of all, to make some observations about the character of public interest which extradition serves. Secondly, I want to deal with the basis on which the compulsory removal of a person from the territory of a convention state is treated as engaging the Article 8 rights of accused persons at all, whether it happens by way of extradition or deportation. This is not controversial as between the parties, but it is important for a proper understanding of the Strasbourg cases, most of which, in fact, arises from deportation cases. It is quite clear that the two categories are governed by the same principles, even though there may well be factual differences between them relevant. Thirdly, I shall turn to the Strasbourg and English case law on proportionality in the context of deportation and extradition, in order to make the point that the test is fact-specific. It does not involve comparing the relative importance of two conflicting principles in the abstract. The state is required to justify its decision on particular facts by showing that it is necessary to extradite the complainant in the particular case in order to satisfy what successive Strasbourg decisions have called a pressing social need. Fourth, I shall submit that this approach, as I have summarized it, is not consistent with any requirement that the complainant should show exceptional circumstances before his Article 8 rights can prevail, whether that requirement be regarded as a rule of law or as a presumption of fact. Fifth, I shall deal briefly with the relevance of delay, which is a factor on the fact of the present case. Having made those 5 points, I will address the particular circumstances of this case and the reasons why we submit that the court should decline to affirm the order and discharge Mr. Norris. Now, the nature of the public interest served by extradition is a point that I can deal quite shortly with. There are 3 related points that need to be made about it. The first is that although the divisional court, both in their judgment and in the question of law framed for this court, identified the honouring of extradition as the relevant public interest. In fact, the relevant public interest is not the honouring of extradition treaties as such. The relevant public interest is the prevention of crime. Article 8 is set out in full at paragraph 11 of the judgment of the divisional court. There is nothing in Article 8.2 about the honouring of extradition treaties, and the public interest in honouring extradition treaties, although I would accept very great, is not in itself a matter which can derogate from a person's Article 8.1 rights. It is relevant only as part of the vast panoply of law which is directed to the prevention of crime.
Do you accept, looking at paragraph 24 of the judgment, that they had the correct approach? You see Lord Justice Laws referring to Article 8.2, and he says, the fight against increasingly globalised crime, denial of safe havens,
Yes.
general benefits of cooperation in an important common cause. I mean, that would be the right way of looking at it.
That would be the right way of putting it. And extradition treaties are, of course, part of the armoury of that purpose.
Yes. Yeah.
The point is of some relevance for this reason, as we shall see when we come to the Strasbourg case law. Much of it is concerned with deportations which are not based on immigration law, but on the criminal law. In other words, they are deportations of convicted criminals who are aliens after serving their sentence on much the same juridical basis as Section 3 of the Immigration Act 1971 in this country. And the fact that these cases are founded on exactly the same public interest as extradition is a matter which increases the value of those cases when we come to them. Now, the second of the 3 points I wanted to make about interest is that the failure of the United Kingdom to extradite Mr. Norris on account of his Article 8 rights would not, in fact, contravene any extradition treaty. This is because the relevant treaty provides that extradition may be refused on any ground specified by the law of the requested party. It is common ground that the relevant extradition treaty for the purposes of this case is the 1972 treaty with the United States and not the 2003 treaty. But the reason for that is that there is a transitional provision at the end of the 2003 treaty which provides that the previous treaty will continue to apply to cases where the papers were served on the relevant court in the requested state before the 2003 treaty was ratified, and that did not occur until 2007. We ratified it earlier than the United States, but the exchange of instruments of ratification did not occur until April 2007. If the court would take volume 5, which is a lever arch file with authorities added after the principal bundles were printed, tab 82 contains the 1972 treaty, and Article 5.2 is the article to which I have referred. Article 5.2 is a list of circumstances in which extradition shall not be granted, and sub-article 2 provides extradition may be refused on any other ground which is specified by the law of the requested party.
Did you say tab 82?
Tab 82, yes. Does your Lordship's bundle not have,
Yes,
at that point, the 1972 treaty? If it doesn't, then I regret that something's gone wrong.
No, I've got it. Thank you very much. Yes.
Page 169 in
Yes,
the page
yes.
numbering is Article 5, and 5.2 is the relevant provision.
Thank you.
Now, Section 87 of the Extradition Act will be found in Bundle 4 of the Principal Authorities bundles at flag 61. It's in straightforward terms which are set out in the Divisional Court's judgment. Section 87 provides that if the judge is required to proceed under this section, i.e. if it has got to this stage, flag 61, he must decide whether the person's extradition would be compatible with the Convention rights within the meaning of the Human Rights Act. Section 87.1 and Section 87.2 over the page then provides if the judge decides the question in subsection 1 in the negative, he must order the person's discharge. Now, Section 87, therefore, bars extradition in cases where it would be incompatible with the accused person's convention rights. And Section 87 is one of a number of bars to extradition which are not specifically addressed in the 1972 treaty, but take effect as exceptions to the treaty by virtue of Article 5.2 of the treaty. What this means is that there is no question of any inconsistency between the honouring of the treaty and the decision of this court under Article 8, whichever way that decision may go.
I mean, presumably that would be true too under the 2003 treaty.
Well, I was coming to the 2003 treaty, where the position is not so straightforward. The 2003 treaty is, for the court's note, at Bundle 4, tab 4, but there is no equivalent expressly in the 2003 treaty of Article 5.2 of the 1972 treaty. But
You said tab
it's
4, I recall, something like
tab 64, forgive me.
64.
The 2003 treaty does not contain expressly a precisely equivalent provision. In our submission, however, it must be implicit for this reason. Both parties to the treaty must have been aware of the limits upon the power to extradite persons under the law of both countries. In the United Kingdom, those limits include not only Section 87, which we've looked at, but Section 80, cases where proceedings in a foreign jurisdiction are affected by what are called extraneous considerations, i.e. race, religion, and so on. Section 82, unjust or oppressive by reason of the passage of time. Section 91, unjust or oppressive by reason of the defendant's physical or mental conditions, and a number of other cases where extradition is barred by statute under the law of the United Kingdom, but no specific provision is made for them in the 2003 treaty. Now, most of those bars also existed under the Extradition Act 1989, which was in force during the period when the 2003 treaty was being negotiated. Moreover, as I have indicated in answer to questions from the court, there are bars in the United States which are likewise not expressly catered for, notably the Fourth Amendment.
It's irrelevant, isn't it? If it isn't in the treaty, that's irrelevant.
It's irrelevant to this case because the 2003 treaty is not the relevant treaty. However, inevitably, your lordships and my lady will be interested in the larger ramifications, and it therefore seemed right to point out that the position is not quite so straightforward under the 2003 treaty for other cases in which that treaty may apply.
But if we were dealing with the 2003 treaty, wouldn't it still be irrelevant on the grounds that that may be the international law position,
yes,
but we've enacted a domestic scheme?
Indeed it would, yes.
I mean, as a matter of interest, have they, in the States, you've spoken of the Fourth Amendment, as I understand it, that enables them still to insist on the prima facie case and so forth. But is there anything equivalent to the Article 8 interest we've got here?
There is no precise equivalent under the constitutional law of the United States to the respect for family life, although there are a large number of constitutional principles derived from various articles of the US Constitution which overlap with it. But I can't say that it's a precise equivalent. Now, since both sides must have been aware that there were bars to extradition under the domestic law on each side of the Atlantic, it must have been implicit that each state would be at liberty to comply with its own law. The significance given the significance of the precedents given in the Extradition Act, Section 87, to the accused person's convention rights is, I would suggest, very much increased by the fact that the Home Secretary's discretion, which previously enabled a wide range of personal and humanitarian considerations to be taken into account, was largely abolished in the Act of 2003. Apart from Section 87, the only opening for such considerations in the 2003 Act is Section 91, which reenacts provisions found in earlier extradition acts, preventing extradition in cases where the accused's physical or mental condition was such that it would be oppressive and unjust to extradite him. Now, I'll say a bit more about Section 91 when I come to deal with the way in which the Divisional Court relied on authorities which were decided under it. But what seems clear is that with the possible exception of Section 91, Section 87 is the sole basis under the current statute law under which humanitarian considerations can enter into extradition decisions. Now, turning to the second of the 5 chapters which I identified at the outset, I can also deal relatively shortly with the basis on which the Convention applies to extradition. It is not an issue between the parties on this, and every member of the court is familiar with it, but I feel I should say something about it because it informs so much of the debate on matters which are an issue. Extradition is not, of course, as such, inconsistent with the Convention. Extradition and deportation are both expressly recognised as permissible grounds of detention in Article 5.1f of the Convention. However, the Strasbourg Court has recognised, ever since the famous decision in Suring, that extradition might be precluded if its practical implications would contravene the accused's convention rights. The court has, I suspect, been referred on many occasions to Suring, perhaps I can briefly do so now. It's in Bundle 3, the Authorities Bundle, at tab 51. It was, of course, an extreme case which arose under Article 3. The relevant statements of principle are at paragraphs 85 to 7 and 91. Paragraph 85 recites Article 5.1f, to which I've just referred, and continues, nevertheless, insofar as a measure of extradition has consequences adversely affecting the enjoyment of a convention right, it may, assuming that the consequences are not too remote, attract the obligations of a contracting state under the relevant convention guarantee. What is at issue in the present case is whether Article 3 can be applicable when the adverse consequences of extradition are or may be suffered outside the jurisdiction of the extraditing state as a result of treatment or punishment administered in the receiving state. Article 1 of the Convention, which provides that the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1, sets a limit, notably territorial, on the reach of the Convention. In particular, the engagement undertaken by the contracting state is confined to securing the listed rights and freedoms to persons within its jurisdiction. Further, the Convention does not govern the actions of states not party to it. It's not convention standards on other states. Article 1 cannot be read as justifying a general principle to the effect that, notwithstanding its extradition obligations, a contracting state may not surrender may not surrender an individual unless satisfied that the conditions awaiting him in the country of destination are in full accord with each of the safeguards in the Convention. Indeed, as the United Kingdom government stressed, the beneficial purpose of extradition in preventing fugitive offenders from evading justice cannot be ignored in determining the scope of application of the Convention and of Article 3 in particular.
What is meant by fugitive?
Well, fugitive, of course, is the traditional term of art. Actually, I think invented by English statute drafters. It's wholly inappropriate as applied to countries which are prepared to extradite their own nationals. Such countries are not the norm, in that it is a particularity of common law countries that they do extradite their own nationals. There is a reason for that historically, but it is most civil law countries will not do so, except now under the European arrest warrant. At the end of the next paragraph, just before paragraph 87, these considerations, and the considerations are the existence of the extradition treaties and conventions as regards torture and maltreatment. These considerations cannot, however, absolve the contracting parties from responsibility under Article 3 for all and any foreseeable consequences of extradition suffered outside their jurisdiction. In interpreting the Convention, regard must be had to its special character as a treaty for the collective enforcement of human rights and fundamental freedoms. Thus, the object and purpose of the Convention, as an instrument for the protection of individual human beings, require that its provisions be interpreted and applied so as to make its safeguards practical and effective. In addition, any interpretation of the rights and freedoms guaranteed has to be consistent with the general spirit of the Convention, an instrument designed to maintain and promote the ideals and values of a democratic society. And then perhaps the other relevant paragraph, present purposes, is paragraph 91. In sum, the decision by a contracting state to extradite a fugitive may give rise to an issue under Article 3 and hence engage the responsibility of that state under the Convention, where substantial grounds have been shown for believing that the person concerned, if extradited, faces a real risk of being subjected to torture or to inhuman or degrading treatment or punishment in the requesting country. The establishment of such responsibility inevitably involves an assessment of conditions in the requesting country against the standards of Article 3 of the Convention. Nonetheless, there is no question of adjudicating on or establishing the responsibility of the receiving country, whether under the general international law, whether under general international law or under the Convention or otherwise, insofar as any liability under the Convention is or may be incurred. It is a liability incurred by the extraditing contracting state by reason of its having taken action, which has as a direct consequence the exposure of an individual to prescribed ill treatment. Now, that last paragraph, which is the conclusion as applied to that case, is directed to Article 3, but the earlier paragraphs, as the Court will have seen, look at the relevance of convention rights generally. Now, both Strasbourg and United Kingdom decisions have treated the general propositions as applying in principle to cases of compulsory removal from the territory of a convention state, whether by way of extradition or deportation. The United States accepts that in paragraph 22 of their printed case, and they accepted it below. Now, in Strasbourg, the leading authority for this proposition is Cruz Varas against Sweden, although there are many cases that follow that decision. That is a decision which the Court will find in Volume 3 of the authorities' volumes, at flag 35. This was another Article 3 case. The complainant objected to being deported under Swedish immigration laws to his native Chile on the grounds that that would expose him to the risk of being tortured by the then government of Chile. The complaint under Article 3 failed on the facts, but it was assessed on the same principles as extradition cases, as one can see from paragraphs 69 and 70 at page 23 of the printout. Paragraph 69, in its Söring judgment of July 1989, the Court held that the decision by a contracting state to extradite a fugitive may give rise to an issue under Article 3, and hence engage the responsibility of that state under the Convention, where substantial grounds have been shown for believing that the person concerned, if extradited, faces a real risk of being subjected to torture or to inhuman or degrading treatment or punishment in the requesting country. Although the establishment of such responsibility involves an assessment of conditions in the requesting country against the standards of Article 3, there is no question of adjudicating on or establishing the responsibility of the receiving country, whether under general international law or the Convention or otherwise, insofar as any liability under the Convention is or may be incurred. It is liability incurred by the extraditing contracting state by reason of having taken action, which has as a direct consequence the exposure of an individual to prescribed ill treatment. Paragraph 70, although the present case concerns expulsion, as opposed to a decision to extradite, the Court considers that the above principle also applies to expulsion decisions and a fortiori to cases of actual expulsion. Now, that formulation has been repeated in a large number of Strasbourg cases since then, and was adopted by the House of Lords in Ulla, a case which will be found reported at tab 23 in volume 2.
You see?
Volume 2, tab 23. Buller and the special adjudicator. The relevant paragraph is at paragraph 13 of the speeches in the speech of Lord Bingham. The respondents drew attention in argument to substantive differences between expulsion and extradition. Such differences plainly exist and may affect the application of the Söring principle. but the Strasbourg Court has held the principle to be potentially applicable in either situation. In Kruth Varas in Sweden, it is said, and they set out paragraph 70 of that judgment, the court has relied on this paragraph directly or indirectly in a series of later cases, among them Vilvaraj, Chehal and the United Kingdom, HLR and France, Ahmed and Austria, Jabari and Turkey, and Hilal and the United Kingdom. I will come back to Ullah in a moment for another proposition for which it is authority. There is, as the court knows, a distinction implicit in the Strasbourg cases and explicit in the English ones between foreign and domestic cases, where the sole basis of the allegation against a convention state is that it has exposed the complainant to treatment by a foreign state, which would be inconsistent with the convention. It has been held that a very high threshold has to be satisfied before convention rights are engaged at all. The threshold has variously been described as one where the breach is flagrant or enormous, to use the less elegant phrase, or perhaps more accurately, where the situation in the requesting state or the state of destination is such that there is a denial of the whole obligation. Now, no such threshold is applied in domestic cases, which are cases where the complaint is that the acts of the convention state itself have contravened the complainant's convention rights. Söring itself was a classic foreign case in accordance with that classification, because the incompatibility with the complainant's convention rights arose entirely from the way in which the complainant would be treated in the United States after his extradition there. Ullah and the case of Razgar, which was decided at the same time, were both foreign cases, which are also the main authorities for the distinction in the United Kingdom's case law. In Ullah, the contention of the complainant was that he would suffer religious persecution in his country of origin. In Razgar, it was that in Germany, which was the country to which the complainant would have been deported, he would not receive medical assistance comparable to that which would be available in the United Kingdom. In each case, the House of Lords held that the obligation of a convention state not to expose the complainant to treatment in a foreign country which would be inconsistent with the convention was confined to cases where the treatment was so extreme as to amount to a denial of right. And that distinction was explained in the speech of Lord Bingham at paragraphs 7 to 9 and further at paragraph 18. The court would turn to paragraph 7. By Article 1 of the Convention, the contracting states undertook to secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of the Convention. The corresponding obligation in Article 2 of the International Covenant on Civil and Political Rights of 1966 extends to all individuals within the territory of the state and subject to its jurisdiction. The difference of wording is not significant for present purposes. Thus, the primary focus of the European Convention is territorial. Member states are bound to respect the Convention rights of those within their borders. In the ordinary way, a claim based on the Convention arises where a state is said to have acted within its own territory in a way which infringes the enjoyment of a Convention right by a person within that territory. Such claims may, for convenience, be called domestic cases. The European Convention was as originally drafted, made no express reference to immigration or extradition, save in sanctioning, in Article 5.1f, the lawful arrest or detention of a person to prevent his effecting an unauthorized entry into the country, or of a person against whom action is being taken with a view to deportation or extradition. Those who negotiated the Convention may have contemplated that Member States' decisions on immigration and extradition would fall out with the scope of the Convention. Such an argument on immigration was indeed put forward by Her Majesty's government in Abdulaziz Cabales and Balkandali, But the Commission rejected this interpretation, and so did the Court, which held at paragraph 60, thus, although some aspects of the right to enter a country are governed by the Fourth Protocol as regards states bound by that instrument, it is not to be excluded that measures taken in the field of immigration may affect the right to respect for family life under Article 8. The Court accordingly agrees on this point with the Commission. The Commission had held, paragraph 59, that immigration controls had to be exercised consistently with Convention obligations, and the exclusion of a person from a state where members of his family were living might raise an issue under Article 8. As this quotation makes plain, however, this was a domestic case. The applicants were wives settled here. They complained that their husbands had been refused leave to enter or remain. They alleged an interference with their family life here. Domestic cases, as I have defined them, are to be distinguished from cases in which it is not claimed that the state complained of has violated or will violate the applicant's convention rights within its own territory, but in which it is claimed that the conduct of the state in removing a person from its territory, whether by expulsion or extradition to another territory, will lead to a violation of the person's convention rights in that other territory. I call these foreign cases, acknowledging that the description is imperfect, since even a foreign case assumes an exercise of power by the state affecting a person physically present within its territory. The question was bound to arise whether the Convention could be relied on to resist expulsion or extradition in a foreign case. It is a question of obvious relevance to these appeals, since the appellants do not complain of any actual or apprehended interference with their Article 9 rights in the United Kingdom. And if the Court would be good enough to turn on to paragraph 18, as observed in paragraph 8 above, Abdulaziz was not a foreign case, since the applicant's complaint related not to the violation of their convention rights under Article 8, which would occur if they were removed to another country, but to the violation of those rights which they would suffer here if their husbands were refused entry or leave to remain. Several authorities cited fell into the same category, some did not, and were of a hybrid nature. The removal of a person from country A to country B may both violate his right to respect for his private and family life in country A, and also violate the same right by depriving him of family life or impeding his enjoyment of private life in country B. Now, as these passages suggest, and in particular paragraphs 8 and 18 of Lord Bingham's speech, deportation orders which are challenged on Article 8 grounds are likely, in the great majority of cases, to be classified as domestic cases because the adverse impact on a complainant's family life arises from his removal in this country from his family. But putting it at its lowest, they will be hybrid cases with characteristics of both categories. And that was the essential point made by my lady, Lady Hale, in Rasgar at one point of her speech. This was a dissenting speech, but not on this particular point. And Rasgar would be found in the previous flag, flag 22. It was decided at the same time as Ulla, and the relevant passages from Lady Hale's speech will be found in paragraphs 41 to 43. My lords, in his opinion in Ulla, my noble and learned friend Lord Bingham draws a distinction between domestic and foreign cases. He defines the former as cases where a state is said to have acted within its own territory in a way which infringes the enjoyment of a convention right by a person within that territory. He defines the latter as cases in which it is claimed that the conduct of the state in removing a person from its territory, whether by expulsion or extradition to another territory, will lead to a violation of the person's convention rights in that other territory. Another way of putting this distinction is that in domestic cases, the contracting state is directly responsible because of its own act or omission for the breach of convention rights. In foreign cases, the contracting state is not directly responsible. Its responsibility is engaged because of the real risk that its conduct in expelling the person will lead to a gross violation of his most fundamental human rights. Ulla and Doe were foreign cases which failed to meet that test. This distinction is vital to the present case. In a domestic case, the state must always act in a way which is compatible with the convention rights. there is no threshold test related to the seriousness of the violation or the importance of the right involved. Foreign cases, on the other hand, represent an exception to the general rule that a state is only responsible for what goes on within its own territory or control. The Strasbourg Court clearly regards them as exceptional. It has retained the flexibility to consider violations of articles other than Articles 2 and 3, but has not so far encountered another case which was sufficiently serious to justify imposing on the contracting state the obligation to retain or make alternative provision for a person who would otherwise have no right to remain within its territory. For the same reason, the Strasbourg Court has not yet explored the test for imposing this obligation in any detail, but there clearly is some additional threshold test indicating the enormity of the violation to which the person is likely to be exposed if returned. Uller and Doe, on their facts, come nowhere near to meeting that test. It is, for reasons given by both Lord Bingham and Lord Steyn, extremely unlikely that a failure to respect religious freedom, which fell short of persecution within the meaning of the Refugee Convention, would do so. This case, however, is concerned with Article 8. In that context, Lord Bingham also refers to a third or hybrid category, and paragraph 18 is quoted. On analysis, however, such cases remain domestic cases. There is no threshold of enormity or humanitarian affront, but the right to respect for private and family life, home and correspondence, which is protected by Article 8, is a qualified right which may be interfered with if this is necessary to pursue some legitimate aim. What may happen in the foreign country is therefore relevant to the proportionality of the proposed expulsion. Now, what is clear is that the Strasbourg Court has recognised cases of compulsory removal where the challenge is being brought under Article 8 as being subject to the ordinary analysis applied to the generality of domestic cases, and it is to that subject, which corresponds to my third chapter in the chapter headings I gave the Court earlier, that I wish now to turn. Now, I want primarily to refer the Court to the Strasbourg case law on compulsory removal and to deal directly with those cases where it has been resisted on Article 8 grounds. And before taking the Court to them, perhaps it might help if I were to identify in advance what points I propose to extract from them, so you know what you're looking for. The first point which I extract from the Strasbourg case law on Article 8 in this context is that there is no threshold of flagrancy or enormity before Article 8 rights can be said to be engaged. The balancing of the complainant's private and family life against the public interests specified in Article 8.2 is approached without any preconception against the application of Article 8. Secondly, the European Court of Human Rights has consistently declined to accept that the balance between a person's private or family life and the various public interests in Article 8.2 can ever be circumscribed by any rule or practice which would require exceptional circumstances to be shown if his private or family life were to prevail. It has rejected that approach in principle, mainly on the grounds that it reverses the primacy of private and family life, which is inherent in the whole structure of Article 8. And it has rejected it in practice by the way in which it has carried out the balancing exercise itself and treated it as a wholly fact-sensitive process. The third proposition, which I thought invite the Court to deduce from this case law, is that the question which the Court has consistently asked when deciding issues of proportionality is whether the removal of the particular individual in the particular circumstances is necessary in order to serve some pressing social need. Not just desirable, necessary. And that is tantamount, in our submission, to asking how much damage, if any, will be done to the relevant public interest identified in Article 8.2 by not removing the individual. Would the damage be so great as to make his removal necessary?
When the word necessary is used, is that any more than just repeating the word of Article 8.2?
The word necessary is repeating the Article 8.2 expression. Necessary to serve a pressing social need is a gloss which has been applied to it by way of explanation in all the principal cases. It's a gloss that in fact dates back to an Article 10 case, Handyside in the United Kingdom, but which has uniformly appeared in all the cases about compulsory removal.
Mr. Sumption, I recognise, of course, that you say that there's some close analogy between these deportation cases where it's part of the domestic law that following imprisonment you deport in the public interest, and extradition cases. But actually, as a matter of interest at this stage, is there any Strasbourg case that deals with extradition in an Article 8 context?
There is not.
Thank you.
Now, the fourth proposition is that not only has the court declined, as I submitted in my first proposition, to apply a threshold of enormity or flagrancy, but once satisfied that the article is engaged, it has rejected any requirement to show exceptional circumstances in the course of the proportionality exercise. Fifth and last, which is directed to the point that my Lord Brown just raised with me, although the Strasbourg cases on the application of Article 8 to compulsory removal are all about deportation orders, the context in which they have arisen is in fact close to extradition. And that is because most of them are not concerned with the ordinary application of immigration controls. They are concerned with the deportation of non-nationals under the criminal law. In the main cases, the complainants have been non-nationals already settled in the country who have been convicted of more or less serious criminal offences and have served sentences of imprisonment. They are then ordered to be deported under what in England would be Section 3 of the Immigration Act 1971. These cases are instructive, we submit, because they engage exactly the same public interest as extradition, namely the prevention of crime. They do not serve that purpose in exactly the same way, but the resemblance is close. Extradition may be said to contribute to deterring crime by making it less likely that criminals will escape justice by remaining outside the jurisdiction where they committed their crimes. Deportation on the ground of criminal convictions may be said to contribute to preventing crime, partly because of its deterrent effect, but also, I suppose, because by physically removing recidivists from the relevant jurisdiction, they improve the likely criminality of the population at home, I suppose at the expense of aggravating it elsewhere. It is perhaps right to add that in some of the criminal deportation cases, deportation was not in fact a permanent exclusion, but essentially a finite period of banishment. I make that point because one of the factual distinctions often raised between extradition and deportation is that at any rate under immigration laws, deportation is intended to be permanent. And that, of course, is true of quite a lot of the criminal deportation cases as well, but it's not true of all of them, as we shall see. Some are cases where the relevant alien was in fact required to absent himself for a finite period, varying from 3 months in one German case to 5 years in a Belgian case. Now, the leading Strasbourg decisions on Article 8 in the context of compulsory removal are all criminal deportation cases, and they are Mustaqim and Belgium, Belgiudi and France, Bultif and Switzerland, and Unya and Switzerland. They were, as I've said, all cases of deportation under the criminal law. Now, Mustaqim, which is chronologically the first, will be found in the third authorities volume at flag 45. The complainant in this case was a Moroccan national who had lived in Belgium since he was a year old. He was a serious recidivist. By the age of 18, he had been convicted of 147 separate offences of theft and robbery and had served 10 short sentences of imprisonment. They would have been considerably longer if he had not been a juvenile for most of his criminal career. After his 147th conviction, he was expelled from Belgium for a period of 10 years, subject to a right to petition to be allowed to return sooner. Now, in the event he did not return to Morocco, he went to Sweden, from where in due course he did petition the Belgian government, and after 5 years the order against him was suspended conditionally upon his behaving himself. He was therefore allowed after 5 years to return, and his complaint was about the losses attributable to the 5 years during which he was excluded from Belgium. Now, if the court would turn to paragraph 41 in the report, page 10 of the printout, there's a heading, Necessary in a Democratic Society. Mr. Mustaqim claimed that his deportation could not be regarded as necessary in a democratic society. The Commission accepted this argument, taking the view that the measure was disproportionate, as the authorities had not achieved a just balance between the applicant's interest in maintaining a family life and the public interest in the prevention of disorder. The government relied on a large number of offences, 147, of which Mr. Mustaqim was accused, the periods of imprisonment which resulted on several occasions, and the exceptional nature of the juvenile division's relinquishment of jurisdiction in favour of the criminal court, and the severity of the sentences imposed by the Liège Court of Appeal. It also pointed out that the youth had continued to commit offences even while under supervision of the juvenile court. Lastly, it emphasised the serious risk of his reoffending. In short, Mr. Mustaqim's dangerousness had made his presence on Belgian territory unacceptable to the community. The court does not in any way underestimate the contracting state's concern to maintain public order, in particular in exercising their right as a matter of well-established international law and subject to their treaty obligations to control the entry, residence and expulsion of aliens. However, in cases where the relevant decisions would constitute an interference with the rights protected by paragraph 1 of Article 8, they must be shown to be necessary in a democratic society, that is to say, justified by a pressing social need, and in particular, proportionate to the legitimate aim pursued. And if we turn on just a few paragraphs lower after an analysis of the facts to paragraph 46, having regard to these various circumstances, it appears that as far as respect for the applicant's family life is concerned, a proper balance was not achieved between the interests involved, and the means employed were therefore disproportionate to the legitimate aim pursued. Accordingly, there was a violation of the applicant's right to respect for his family life.
You emphasised a little earlier that necessary didn't mean desirable.
Yes.
We see a paraphrase here, which I notice is picked up also in the intervener's case, which really redefines or expands the phrase necessary in a democratic society.
Yes.
Am I right in suggesting so that it means justified by a pressing social need and proportionate to the legitimate aim pursued?
Yes, that is so. I mean, proportionality, of course, is fundamental to the whole of the Convention and necessary for the purpose of addressing a pressing social need is a phrase that was originally formulated by the court in Handyside, which was an Article 10 case. I'm going to refer to that in due course. But that Handyside was the case where the court emphasised the difference between being necessary and being desirable. Now, what one sees in Mustaqim is a highly fact-specific inquiry. I haven't read through the whole of the analysis of the facts, much of which is found in the Commission in abbreviated form in the Court's decision, but it's completely free of the kind of categorization and presumptions that in our submission vitiates the reasoning of the Divisional Court in this case. That is also a characteristic of all the subsequent cases on the same line. Now, the second of them, Belgiudi, is to be found in Volume 2 of the authorities volume at flag 30. This was a petition from France, and this is a very interesting case indeed, because it marked a major turning point in the development of French law in this area, which had previously somewhat pooh-poohed the idea that at any rate Article 8 could be relevant in this kind of context. Mr. Beljoudi was an Algerian national born in France and married to a French woman. He had served 6 sentences of imprisonment.
Sorry, which tab are we in?
Tab 30 in Volume 2. He had served 6 sentences of imprisonment, the longest of which had been a sentence of 8 years, and these involved serious offences involving violence, dishonesty, and possession of firearms. He was ordered to be deported. Now, in France, the practice in both extradition and criminal deportation cases is very elaborate. They are initially matters for the ordinary courts, with a line of appeal going up to the Cour de Cassation. And the function of those courts is to determine whether there is any legal basis for deportation or extradition. If there is, then the matter is referred to the minister for decision. The minister's decision is then subject to judicial review before the administrative courts, culminating in the Conseil d'État. And the proper mode of challenging an extradition or deportation on convention grounds is a judicial review of the minister's decision in the administrative courts. The original approach of the Conseil d'État in cases of this sort was that deportation of dangerous criminals served an important public interest, and that in principle, Article 8 could not prevail over an extradition order which satisfied the ordinary requirements of public law, which are substantially similar to those that exist in this country. For many years, the leading case was the decision of the Conseil d'État in 1980 in a case called Touami ben Abdel Salam, and if, keeping Beljoudi open for a moment, the court would be kind enough to turn to Volume 4 at flag 60, you'll find the report of that case in French and with an English translation immediately afterwards, which comes from the Recueil Le Bon, which is the official series of reports of decisions of the Conseil d'État. And if you look in the English text, the French text sits at the bottom of the second page. In the English text, it's the first full paragraph on the last page of this flag, whereas Mr. Touami cannot effectively rely on either the provisions of Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, under the terms of which any person has the right to respect for his private and family life, his residence and correspondence, or the general principle of law, according to which foreigners resident in France have the right to conduct a normal family life, in support of his submission to set aside a deportation order of which he is subject. Whereas, as a result of the above, Mr. Touami is not well founded in maintaining that the Administrative Court of Clermont-Ferrand was wrong by the challenged judgment dated the 8th of May 1979. So the decision was that, in principle, an Article 8 defence is not available. If the court would look at the French text, you'll see that the opening words are "Un étranger ne peut utilement se prévaloir." That is translated effectively. Essentially, what is being said is not that Article 8 lies outside the jurisdictional domain of the administrative courts. What is being said is that the general principle of maintaining public order by deporting undesirable aliens will, of its nature, prevail over the general principle for respect for family life, so that it is pointless to make use of Article 8 in that context. Now, what happened in Beljoudi was that after the minister had made the order, Mr. Beljoudi sought judicial review of the order in the Versailles Administrative Court. And in the Beljoudi report, flag 30 of volume 2, at paragraph 25 on page 5 of the printout, there are 3 bullet points, the last of which expresses the essence of the Versailles Court's decision. Considering that Mr. Beljoudi is not justified in relying on provisions emanating from the Declaration of the Rights of Man and the Citizen, claiming to this end the benefit of provisions of Article 25, as amended in a version subsequent to the decision appealed against, and having regard to the fact that the measure taken against the applicant was necessary for public safety, he is not entitled to take advantage of the freedoms of Article 8 of the European Convention on Human Rights and Fundamental Freedoms. Now, Mr. Beljoudi appealed from that decision to the Conseil d'État. He simultaneously petitioned the European Court of Human Rights while his appeal was still pending. And what he said was that he didn't need to exhaust his domestic remedies first, because the rule in Tuami meant that his convention rights could never prevail under French law as it then stood. By the time his case was heard by the Conseil d'État, the Commission had already acceded to that submission. They ruled his case to be admissible and had held that there was a violation of Article 8. That case went on to the court, but the Commission's reasons themselves repay study. As always in reports of the Strasbourg Court at this particular stage, it's not easy to work out where judgments begin and facts end. But if the court would turn to paragraph 52, the Commission's decision begins at that point. The previous part
Is this page 13?
Page 15.
15.
Paragraph 52. Unless your Lordship has a different printout to mine.
Yes, I've got
Oh,
it.
I'm told that there are 2 52s.
Yes, under opinion.
Yeah, under opinion, that's where the Commission decision begins. And the relevant part of it for this purpose, you can go straight to paragraph 59. As to the aims pursued by the deportation order, the Commission, like the Government, considers that the deportation order was manifestly aimed at the prevention of disorder and crime. In view of the first applicant's convictions prior to 1979, including a case of aggravated theft for which he was sentenced to 8 years' imprisonment, the purpose of the expulsion was to safeguard public order in France. Looking in the light of Article 8 of the Convention, therefore, the interference at issue was in line with the legitimate aims authorized by the Convention. According to the applicants, the interference complained of cannot, however, be regarded as necessary in a democratic society. And the judgment then goes into the details of the facts and to his criminal record in particular. And taking up the reasoning at paragraph 62, with regard to the interpretation of the expression necessary in a democratic society, the Commission recalls, first of all, that in determining whether an interference is necessary in a democratic society, it is appropriate to be taking account of the margin of appreciation left to contracting states. It is true that the Convention does not in principle prohibit contracting states from regulating the entry and length of stay of aliens. However, the criterion of necessity implies that the interference corresponds with a pressing social need, and in particular, that it is proportionate to the legitimate aim pursued. In considering whether this latter condition has been met, the Commission notes that it is not required to pass judgment on the policy as such applied by France to the expulsion of second-generation immigrants. Its main role is to ascertain whether, in the present case, a fair balance has been struck between the legitimate aim pursued and the seriousness of the interference with the applicant's right to respect for their family life. Now, I've described this process as fact-specific, and that last paragraph is a very clear statement of the principle. What the court is doing, and what this court should be doing, is not considering the significance of the principle of extraditing people as an abstract principle. It is concerned with ascertaining whether in the present case a fair balance has been struck between that principle and the seriousness of the interference with the relevant convention right. Finally, paragraph 68, it follows that in the present case, there are no exceptional circumstances which, in spite of the integration of the first applicant into French society, would be such as to justify his deportation to Algeria. Consequently, his deportation would constitute an interference with the exercise of the rights secured to the applicants by Article 8.1 of the Convention and would not be justified under Article 82. Now, there one can see the concept of exceptional circumstances being applied in diametrically the opposite way, and the correct way. You have to produce exceptional circumstances to show that an infringement of Article 8.1 is justified. Now, when the matter, that was the Commission's decision, when the matter came up for hearing before the Conseil d'État, the Court was invited by the government through its standing counsel. The government commissioner in the Conseil d'État effectively acts as an amicus curiae, or performs a function not dissimilar to that of the Advocate General in the Luxembourg Court. When it came up before the Conseil d'État, the Government Council invited the government, through its standing council, to abandon the principle in tuami, because it was, among other reasons, it was not consistent with the development of the case law of the Strasbourg Court. The course of events is in fact set out in the subsequent judgment of the Court itself, in the same report, which sets out in full the relevant parts of the government's submissions before the Conseil d'État, a slightly unusual course, which was justified because of the considerable importance of these submissions in explaining what the Conseil d'État subsequently did. Paragraph 27.
So we're on the same time?
We are now... Sorry, I'm now also getting into difficulties with the paragraph numbering. I think you need to turn to page 5 of the printout, and at the bottom of page 5, under the heading Before the Conseil d'État, paragraph 27 sets out the Government Commissioner's submissions, Mr. Ronnie Abraham. Now, I'm not going to read large chunks of these submissions, although they are, in fact, extremely interesting. The critical parts of them are, first of all, you'll see at the top of page 6 a reference to the Tuame decision with a brief quotation from it. And after that reference, there's a paragraph beginning, "This is the dominant line of your case law, although there are some decisions in which you appear to have taken a position on the merits and circumstances of the case in order to reject the ground of appeal," and some of those are cited. Whatever the position may be on these uncertainties, we will suggest to you today that you definitely abandon the solution laid down in the Tuame Ben Abdel Salem judgment and adopt an entirely new approach to the question before us. And he gives 3 principal reasons, most of which, or 2 of which, are grounded in principles of French law. And I think perhaps one can pick this up at the last paragraph on page 5. More simply, it seems probable to us that you considered that a deportation order was not itself an interference with the alien's family life. If the alien has family ties on French territory, nothing prevents the other members of the family group leaving France with him. But this is a very theoretical way of looking at things. It is no doubt correct that in certain cases there is nothing to prevent the family leaving French territory. But in other cases, especially if the alien has a spouse or children of French nationality, it may be difficult on practical or even legal grounds for other members of the family to follow him, with the effect that the expulsion measure jeopardizes the pursuit of an ordinary family life. In any event, it is in our opinion, not possible to state that a deportation measure can never of itself be capable of interfering with the family life of the person concerned, and there is no reason to dismiss a priori as ineffective a ground of decision based on Article 8. There is a second reason which supports us in this view. Your case law is not at all in harmony with that developed by the European Court of Human Rights in recent years. In the Behrab and Netherlands judgment, the Strasbourg court defined for the first time the possible impact of Article 8 on expulsion measures against aliens. The substance of the decision was that where the alien has real family ties in the territory of the state in which he is resident, and the expulsion measure is such as to jeopardize the maintenance of those ties, the measure is justified with regard to Article 8 only if it is proportionate to the legitimate aim pursued. In other words, if the interference with the family life which follows from it is not excessive with respect to the public law interest to be protected. The balance between public and private life induced the court to find in the Behrab case that there had been a violation of the convention by the Netherlands with respect to an alien who was the father of a child born in a dissolved marriage with a Dutch woman and who had been refused renewal of his residence permit for purely economic reasons. Behrab was not a criminal deportation case. It was decided under the standard immigration laws. Such an intellectual exercise ought not to disconcert you, and we see nothing to prevent you henceforth adopting it as yours with reference to the deportation of aliens, provided, of course, that Article 8 is in fact pleaded. Reviewing proportionality is among your tried and tested techniques, and the concept of a balance to be struck between divergent public and private interests is certainly not unfamiliar to you, since you constantly make use of it in certain other contexts.
The proviso wouldn't apply to us. We would have a duty of our own motion.
Sorry?
The proviso would not apply to us.
Yes.
We would have to
you would be obliged.
Of our own motion.
Yes, and I believe that is actually also now recognised as being the position in France, because of the point about positive obligations, not just negative ones. The submission then goes on to say, furthermore, maintaining your case law, as in Tuami, would have the awkward consequence of making appeals to the Strasbourg institutions directly available to aliens who were the subject of a deportation order and complained of an interference with their family life, without their being obliged first to have recourse to the domestic courts. For it is a known fact that according to the consistent case law of the European Commission, the rule that internal remedies must first be exhausted, which under Article 26 of the Convention is a condition of admissibility of individual applications submitted to the Commission, must be understood as imposing on an applicant the obligation only to have prior recourse to internal remedies which have a reasonable chance of success, having regard in particular to the case law of the highest courts, with the effect that a definite line of case law, excluding a priori the taking into account of Article 8 of the Convention, would entitle an alien to take his claims directly to the European institution. And the present case, he says, is an instance of that, because by the time these submissions were delivered, the Commission had indeed ruled in Mr. Beljudi's favour. Now, the government invited the Conseil d'État to conduct a full proportionality assessment, but to conclude, having done so, that deportation was proportionate and justified on its facts. And the Conseil d'État acceded to that submission, as one can see from the summary of its decision in paragraph 28 of the report in the Strasbourg court. The essential point is at the very bottom of page 9 of the printout, the last bullet point on that page. They set out Article 8, and over the page, proper page 10, the measure appealed against, based on the defence of public order, was necessary for the defence of that order in view of the applicant's conduct and the seriousness of offences committed by him. In these circumstances, it was not in violation of Article 8 of the Convention. That is a quotation from the Conseil d'État's decision, and the Conseil d'État's own reasoning on that begins at paragraph 74, which is on page, two numberings. This one is on page 24 of the printout. The actual judgment of the court begins on page 22 at paragraph 65. Paragraph 74 on page 24, the court acknowledges that it is for contracting states to maintain public order, in particular by exercising their right as a matter of well-established international law and subject to their treaty obligations to control the entry, residence and expulsion of aliens. However, their decisions in this field must, so far as they may interfere with a right protected under paragraph 1 of Article 8 be necessary in a democratic society, that is to say, justified by a pressing social need, and in particular proportionate to the legitimate aim pursued. And then paragraph 77, after a reference to various facts in Beljudi's case, Mr. Beljudi, the person immediately affected by the deportation, where they set out the facts of his life and his family life in particular. And at paragraph 79, having regard to these various circumstances, it appears from the point of view of respect for the applicant's family life that the decision to deport Mr. Beljudi, if put into effect, would not be proportionate to the legitimate aim pursued. So ultimately, although the Strasbourg, the Conseil d'État had carried out a full proportionality assessment, the Strasbourg court, in accordance with its practice, carried out its own and reached a different conclusion. Now, the impact of Beljudi in deportation cases can be measured by the subsequent decision of the Conseil d'État in Beljacem, which in my submission very accurately expresses the test as I submit to this court it should be applied. Beljacem is at volume 4 of the authorities' budget. At tab 58, it was decided a bit later in the same year as Beljudi. Just to summarize the facts, Mr. Beljacem was an Algerian national who had been convicted of a number of serious offences of robbery. They included a conviction for participating in an armed robbery with 2 accomplices at a social security payment centre, for which he had received a sentence of 6 years imprisonment. Mr. Beljacem had lived all his life in France, where he had 12 siblings and supported his aged father. The formula with which his Article 8 rights were held to prevail over the public interest by the Conseil d'État appears at page 2 of the printout in the English translation. It's on the second page of the French text, but reading from the English, starting halfway down the page, whereas Mr. Beljacem, an Algerian national, has no family ties with the country whose nationality he possesses, he has lived in France since his birth in 1958, where his family lives, consisting of 9 brothers and sisters, for whom he, with his older brother, assumed a share of the responsibility following the death of his father in 1976. If the interested party is found guilty in several thefts in 1980 and 1982, it emerges from the documents in the file that, given his behaviour after the convictions pronounced for these acts, the deportation order against Mr. Beljacem, given the seriousness of the adverse effects on his family life, exceeded what was necessary for the defence of public order. Under these conditions, it was brought in breach of Article 8 of the above-mentioned convention. So that the reasoning acknowledges the importance of defending the public order, but asks, do the facts of this particular case make it necessary, in order to vindicate that public order, to deport this particular individual? Now, I will not refer to it, but there is an article at tab 73 in volume 4, or possibly more usefully tab 83 in volume 5, where we put not just the printout but the actual photocopy of the article, in the Revue Française de Droit Administratif, which sets out in full the submissions of Mr. Abraham, still the government advocate, and they contain an interesting survey of the development of both Strasbourg and domestic French case law on this subject, as well as a rather fuller account of the facts from which I have drawn in summarising the case.
Is there a particular passage that you want us to look at?
No.
I suggest we look at it in...
No, there is not a particular... It is put before you as background.
Yes.
But what you will find there is, apart from a fuller account of the case, which I have provided in my feet, you will find a brief history of the way that this has developed in a manner that required an alteration of French approaches. But what is quite striking about the French example is that the original approach of the French court in deportation cases was very much in line with what one would expect, without any disrespect, to be a natural judicial reaction in such cases. Surely all cases of criminal deportation are going to be cases, or virtually all cases, are going to be cases where there is an interference with family life. How are we supposed to manage this? It is quite clear, in particular from Mr. Abraham's submissions in the Belgiudi case, that a considerable change of direction was required in fundamental judicial attitudes in order to bring it into line with the jurisprudence of the Strasbourg court. And the opening assumption, what's special about this case, is one that simply does not meet the case. Now, I will deal in a few moments with the position on extradition in France, which is different, and I'll discuss that. But before I do, can I turn to the third in the line of criminal cases, criminal deportation cases from Strasbourg, which is Bultief, and that is going to be found in volume 2 of the authorities bundle at flag 32. This contains the fullest statement, although it doesn't profess to be a comprehensive or exhaustive statement, of the matters that will need to be brought into account in carrying out the proportionality assessment under the law of the Strasbourg court. The facts were that the claimant in this case was an Algerian national who had lived in Switzerland under a residence permit, in fact for quite a short period of time. He moved to Switzerland at the age of 25. He married a Swiss lady shortly after his arrival, and after he had been in Switzerland for a period of about 18 months, he committed an extremely brutal street robbery for which he was sentenced to 2 years' imprisonment. Upon his release, the Swiss authorities declined to renew his residence permit. The general principles which the court applied in this case appear from paragraph 48 at page 7 of the printout. The court has only to a limited extent decided cases where the main obstacle to expulsion is the difficulties for the spouses to stay together, and in particular for a spouse and or children to live in the other's country of origin. It is therefore called upon to establish guiding principles in order to establish whether the measure was necessary in a democratic society. In assessing the relevant criteria in such a case, the court will consider the nature and seriousness of the offence committed by the applicant, the length of the applicant's stay in the country from which he is going to be expelled, the time elapsed since the offence was committed, as well as the applicant's conduct in that period, the nationalities of the various persons concerned, the applicant's family situation, such as the length of the marriage, and other factors expressing the effectiveness of a couple's family life. Whether the spouse knew about the offence at the time when he or she entered into a family relationship, and whether there are children in the marriage, and if so, their age. Not least, the court will also consider the seriousness of the difficulties which the spouse is likely to encounter in the country of origin, although the mere fact that a person might have faced certain difficulties in accompanying her or his spouse cannot itself exclude an expulsion. Now, that's not put forward as an exhaustive list, but it is a good catalogue of those that arise most commonly, and almost all of them, in fact, relevant in this particular case also. If the court turns on to paragraph 50, just below that.
Yes.
I'm sorry, my lord.
I was going to ask you about paragraph 50.
Yes. Paragraph 50 is where they start their analysis of the facts in this case. The court has first considered the extent to which the offence committed by the applicant served to assume a danger for public order and security. It is true that the applicant committed a serious offence and was sentenced to a prison sentence, which he has in the meantime served. The court further notes that the Zurich District Court, in its judgment of May 95, had only envisaged a conditional prison sentence of 18 months' imprisonment, suspended on probation, as an adequate punishment for the offence committed by the applicant. the Zurich Court of Appeal later pronounced an unconditional sentence of 2 years. Furthermore, the offence at issue was committed in 1994, and in the 6 years thereafter, until the applicant's departure in 2000, he committed no further offence. Before he commenced serving his prison sentence, he obtained professional training as a waiter and worked as a painter. His conduct in prison was without blemish. Indeed, he was released prematurely. As from May 1988 until his departure from Switzerland in 2000, he worked as a gardener and electrician with the possibility of continued employment. As a result, while the offence which the applicant committed may give rise to certain fears that for the future he constitutes a danger to public order and security, in the court's opinion, such fears are mitigated by the particular circumstances of the present case. The court has next examined the possibility of the applicant and his wife establishing family life elsewhere. The court has considered first whether the applicant and his wife could live together in Algeria. The applicant's wife is a Swiss national. It's true that the applicant's wife can speak French and has had contact by telephone with her mother-in-law in Algeria. However, the applicant's wife has never lived in Algeria. She has no other ties with that country and indeed does not speak Arabic. In these circumstances, she cannot, in the court's opinion, be expected to follow her husband, the applicant, to Algeria. There remained the question of establishing family life elsewhere, notably in Italy. In this respect, the court notes that the applicant lawfully resided in Italy from 1989 to 1992, when he left for Switzerland, and it appears that he is now again residing with friends in Italy, albeit without regular status. In the court's opinion, it has not been established that both the applicant and his wife could obtain the authorization to reside lawfully, and as a result to lead their family life in Italy. In that context, the court has noted that the government has argued that the applicant's current whereabouts are irrelevant in view of the nature of the offence which he had committed. The court considers that the applicant has been subjected to serious impediment to establish family life, since it is practically impossible for him to live with his family outside Switzerland. On the other hand, when the Swiss authorities decided to refuse his continuing stay in Switzerland, the applicant only presented a comparatively limited danger to public order. The court is therefore of the opinion that the interference was not proportionate to the aim pursued. There has accordingly been a breach of Article 8 of the Convention. Now, Bulteef was endorsed as a matter of principle.
Can I just go back to paragraph 50 then? I mean,
yes.
What they're looking at there rather looks like an assessment of the risk that the applicant would continue to offend in the future.
Well, that's certainly part of it, yes.
I mean, we're dealing with a rather different situation here, of course, because, of course, there is a threat of a prosecution, there's a plea of not guilty,
yes.
and so on. But then, so the question really would be here more as to whether it's desirable in the interests of meeting allegations of crime and so on that people should be put on trial for their offences.
Yes.
So we don't get any guidance here on that point.
You certainly don't get any guidance here on that particular point, but the situations are not, I would suggest, as different as your lordship suggests. Why does one deport convicted criminals? Essentially, leaving aside just the advantage of removing somebody who is a menace, and this gentleman clearly had an extremely short fuse, the reason one does it is, at least in part, to deter both that individual and other individuals from committing offences. Now, when one asks, in what way does extradition contribute to the public interest in the prevention of crime, it contributes to it by deterring people from committing crimes, both, I suppose, the particular offender or alleged offender, and others who might be less likely to commit crimes if they knew that they would not remain unpunished, regardless of their geographical location. I mean, you might equally say, in Mr. Norris's case, nobody, I think, suggests that he is going to commit criminal offences if he is not extradited. The relevance of this, therefore, is entirely the deterrent effect on others. Now, the deterrent effect on others is not expressly mentioned in the analysis of the European Court in Bulteef, but it is clearly there and a relevant factor. That's why they go through, in paragraph 48, matters relevant to the seriousness of the offence and so on. That's one reason why they do.
deterrence is not the only factor that is taken into account in the public interest when you try and sentence somebody.
No, but if one is talking about the prevention of crime, it's difficult to think. There are, of course, public interests in convicting people who have committed crime, quite irrespective of deterrence. But if you ask yourself what is the public interest in the prevention of crime, which is the relevant public interest for H2 purposes, it's difficult to think of anything other than deterrence, either of the individual or of others in a similar situation.
Mr. Sumption, is there any domestic or Strasbourg jurisprudence on the relationship between Article 8 and ordinary sentencing in criminal cases?
There isn't, and clearly this is an area which it has been flagged up in this sense. There are cases dealing with whether it's not in an Article 8 context. There are cases in which other provisions of the Convention, notably Article 3, have been marshalled in support of a proposition that a life means life sentence without any possibility of parole may constitute maltreatment within Article 3. That is a slightly different point, but it is in the same general area. It is also the case that the Strasbourg Court has taken a growing interest in conditions of detention, which is disclosed in the various Strasbourg decisions that deal with the right of privacy, an Article 8 right, in the context of prisoners' correspondence and prisoners' right to facilities for artificial insemination. Dixon, which comes into the latter category, is the best known case in which the European Court has reviewed, in fairly general terms, conditions in prisons. Now, what we appear to be building up to, or there's no actual decision to this effect at the moment, is that an ordinary sentence of imprisonment in a wholly domestic context may be susceptible to Article 8 considerations if conditions of imprisonment, in particular in relation to visiting rights, are such as to cut off, to an extent greater than is necessary, a visitor's social life. What I would say in answer to the concern that I detect in your ladyship's question, perhaps wrongly.
Try not to do that, Mr. Sumption.
All right.
Let me do it entirely
spontaneously. If I were in your ladyship's position, I would expect to wonder what happens about ordinary sentences of imprisonment.
No, I had a reason for asking, Mr. Sumption, which is that there was a case when I was in the Court of Appeal which considered the impact of Article 8 on sentencing, a prison sentence.
Was that Warren?
No.
Right.
No, it had initials because it had to do with children.
Right.
And it was about the sentencing of mothers.
Right.
And the separation of mothers and babies for the purpose of serving criminal sentences. I know not whether it had anything interesting to say, I can't remember, but I do remember that there was just such a case. Right. And it was with that in mind that I asked the question, because it seemed to me that it might be relevant to see whether there was anything, either here or in Strasbourg, that dealt with that much more common situation than the extradition situation, and clearly much more in point than almost anything else we've been talking about.
Well, I'm not sure I would accept the latter point, but I will find the case. I don't...
I think it's called P&Q or something unhelpful like that.
Right. We will find it. And
it may have nothing of any helpfulness in it.
Well, I will identify the case in due course, and if it's relevant either way, I will put it before the court.
If it be the case that there's a very marked disparity in sentence lengths in different European jurisdictions, either it's just that Strasbourg hasn't considered this area, or there's an enormous margin of appreciation granted to individual states in relation to the extent to which they interfere with family life by way of punishment.
Well, there is of course, this is a fairly rapidly developing area of law, and there is a considerable disparity. I mean, it is well known that this country and France are at the top of the list as far as length of prison sentences is concerned, by quite a considerable margin. first of all, of course, many of the Article 8 factors are relevant as part of a sentencing discretion in any event. The greater the impact on family life, the greater one particular line of mitigation would obviously be. Moreover, it is fair to say that what is generally regarded as making a sentence of imprisonment, even if it's quite long, consistent with the maintenance of family life, is the preservation of such matters as visiting rights. And this was something that was dealt with in the Dixon case, which was about the compatibility with the Convention of the extremely restrictive policy then applied by the Home Office in relation to artificial insemination. I'm going to refer to that case in due course. Unia and the Netherlands, which is the last of the 4 cases that I identified earlier, is at bundle 3, flag 53. Mr. Unya was a Turkish national resident in the Netherlands. He had married a Dutch woman and he had had children with her who were, of course, Dutch citizens. He was sentenced to 7 years imprisonment for killing a man in the course of a cafe brawl. His residence permit was then withdrawn by the Dutch authorities and he was ordered to leave the Netherlands for 10 years. The question whether he would recover a residence permit after 10 years was left open. It would depend on, among other things, a review of his criminal record at that stage. The complaint, in fact, failed on the facts in this case, but the principle was endorsed as taken from the Bull Chief case. And the court will find that at paragraph 54 on page 13 of the printout. The court reaffirms at the outset that a state is entitled as a matter of international law and subject to its treaty obligations to control the entry of aliens into its territory and their residence there, and various cases are cited. The Convention does not guarantee the right of an alien to enter or reside in a particular country, and in pursuance of their task of maintaining public order, contracting states have the power to expel an alien convicted of criminal offences. However, their decisions in this field must, insofar as they may interfere with a right protected under Article 8.1, be in accordance with the law and necessary in a democratic society, that is to say, justified by a pressing social need, and in particular proportionate to the legitimate aim pursued. And there are references to further cases, including Bull Chief. And I think one can pick it up about 2/3 of the way through paragraph 56. Bottom 8 lines. It is, moreover, of the view that a decision to revoke a residence permit and or to impose an exclusion order on a settled migrant following a criminal conviction in respect of which that migrant has been sentenced to a criminal law penalty does not constitute double punishment, either for the purposes of Article 4 of Protocol 7 or more generally. Contracting states are entitled to take measures in relation to persons who have been convicted of criminal offences in order to protect society, provided, of course, that to the extent that those measures interfere with the rights guaranteed by Article 8, paragraph 1 of the Convention, they are necessary in a democratic society and proportionate to the aim pursued. Such administrative measures are to be seen as preventive rather than punitive in nature. That may cast light on the point that my Lord Hope raised with me apropos the analysis in Bull Chief, the preventive character of the order as the court saw it. Over the page, even if Article 8 of the Convention does not therefore contain an absolute right for any category of alien not to be expelled, the court's case law amply demonstrates that there are circumstances where the expulsion of an alien will give rise to a violation of that provision. and certain cases are cited, including Mustaqim and Beljoudi. In the case of Bultif, the court elaborated the relevant criteria which it would use in order to assess whether an expulsion measure was necessary in a democratic society and proportionate to the legitimate aim pursued. And it then sets out the Bultif criteria and continues, the court would wish to make explicit two criteria which may already be implicit in those identified in the Bultif judgment. The best interests and well-being of the children, in particular the seriousness of the difficulties which any children of the applicant are likely to encounter in the country to which the applicant is to be expelled, and the solidity of social, cultural and family ties with the host country and the country of destination. As to the first point, the court notes that this is already reflected in its existing case law and is in line with the Committee of Ministers' recommendation on the legal status of persons admitted for family reunification. As to the second point, it's to be noted that although the applicant in the case of Bultif was already an adult when he entered Switzerland, the court has held the Bultif criteria to apply all the more so to cases concerning applicants who were born in the host country or who moved there at an early stage. Indeed, the rationale behind making the duration of a person's stay in the host country, one of the elements to be taken into account lies in the assumption that the longer a person has been residing in a particular country, the stronger his or her ties with that country, and the weaker the ties with the country of his or her nationality will be. Seen against that background, it is self-evident that the court will have regard to the special situation of aliens who have spent most, if not all, of their childhood in the host country, were brought up there and received their education there. The court considers itself called upon to establish guiding principles in the Bultif case because it had only a limited number of decided cases where the main obstacle to expulsion was that it would entail difficulties for the spouses to stay together, and in particular for one of them and or the children to live in the other's country of origin. It's to be noted, however, that the first three guiding principles do not as such relate to family life. This leads the court to consider whether the Bultif criteria are sufficiently comprehensive to render them suitable for application in all cases concerning the expulsion and or exclusion of settled migrants following a criminal conviction. It observes in this context that not all such migrants, no matter how long they have been residing in the country from which they are to be expelled, necessarily enjoy family life. However, as Article 8 also protects the right to establish and develop relationships with other human beings and the outside world, and can sometimes embrace aspects of an individual's social identity, it must be accepted that the totality of social ties between settled migrants and the community in which they are living constitute part of the concept of private life within the meaning of Article 8. Regardless of the existence or otherwise of a family life, therefore, the court considers that the expulsion of a settled migrant constitutes interference with his or her right to respect for private life. It will depend on the circumstances of the particular case whether it is appropriate for the court to focus on the family life rather than the private life aspect.
What we get from these authorities is a very close concentration on all the relevant circumstances, personal and others, and that, of course, is part of your main submission. But if the court ever had to consider a case like the present of extradition, or even a case like my lady's of a prison sentence, it would no doubt identify a number of differences in the situation, wouldn't it? It would the decanting of someone elsewhere in these deportation cases, usually on a permanent basis, necessarily displaces the family relationship. But the point about extradition is that there isn't necessarily going to be any family relationship. If it leads to a conviction, there's going to be a permanent or pretty permanent disruption, subject to your points about, of course, visiting being less easy abroad, which would no doubt come in. And there is a strong interest, isn't there, in the doing of justice, which, since the deportation cases aren't cases of punishment, doesn't really apply in those cases, does it?
Well, what does apply in those cases, first of all, your Lordship is absolutely right, but what does apply in those cases is the notion of preventing crime in exactly the way that this case said. This is regarded as a preventative and not a punitive measure, and it is its preventative character that brings it within Article 8.2 in principle.
It's rather odd prevention of crime, isn't it? Because you're actually decanting the criminal to another country, and I don't know whether any European court case has pointed out that all you're doing is offloading the problem, and perhaps you ought to think about the victims in the other country.
Well, that is true.
Well, that's why I was wondering whether when you're talking about necessary in a democratic society, you're talking about your own society.
Well,
I mean, it's a very self-centered approach, and it may make sense in these deportation cases, because the whole idea is that a country is entitled to do this, I suppose, in order to reduce the risk to people who are resident in his own country. But we're not talking about that in this case at all.
No.
That's why I suspect that the whole thrust of the argument against you on this is quite different. It's talking about the international effort in dealing with cross-border criminal activity and the desirability of ensuring that people who are, I don't use the word fugitive in this case in the sense of people trying to run away, but nevertheless that they should be brought before the country where the harm has been done in order that they could be dealt with there.
That is right. But I'm not seeking to belittle in any way the importance of those principles. But what I am pointing out is that not all the public interest advantages of extradition are within Article 8.2. Only those which are relevant to the prevention of crime are. That's why I began by making the point that we are actually not concerned with the interest in observing treaties as such, but only with the prevention of crime. Yeah. The United Kingdom, like any state, has a public interest in the observation of treaties, which is far broader than simply the prevention of crime. It's an interest in doing it even if it didn't prevent crime.
You're not saying, are you, that when you use the phrase prevention of crime, we're looking only to the prevention of crime within the United Kingdom? Well, you're not taking that sort of narrow reading.
No, I am not saying that, and in an extradition case that would be a wholly inappropriate submission to make. But it is undoubtedly true that the notion of preventing crime at home is coupled with a degree of indifference to the contribution that the deportee may make to the promotion of crime elsewhere. I suppose that if that point had been raised, and I'm not aware of any Strasbourg case where it has been, the answer would be that if you are a non-national, your country of nationality may have to put up with the problems of your recidivist behaviour in a way that may not perhaps be expected to quite the same degree of other countries where you're a guest.
Mr. Sumption, in this context, may it be relevant to consider what your position would be if Mr. Norris had actually been tried and convicted in the United States and pending sentence had become a fugitive, so far as they're concerned, come back here in order to escape, let's say, a sentence of 3 years imprisonment? In that situation, would you really have any...
Let's suppose that he'd been arrested outside, so that there'd been no previous extradition.
Yes, he happened to be there, arrested, tried, and then before serving his sentence, he absconds back to the United Kingdom.
I would accept that in that situation, the public interest, or the weight to be attached to the public interest in extraditing him to serve the rest of his sentence would be greater, possibly much greater.
But the considerations of public interest are the same, aren't they, on your argument? Prevention of crime.
Well, the considerations would be the same because the deterrent aspect of it would be much the same. In my submission, the rationale for extradition is deterrent in the sense that it deters not just the particular accused person, but also the rest of the criminal or allegedly criminal confraternity. Now, that's a consideration that would arise in exactly the same way on your lordship's scenario as it does here. The public interest in Mr. Norris being tried in the United States is in the same category as the public interest if he is tried and is sentenced to a period of imprisonment in his serving it. That I would entirely accept, although I suspect that the latter, because it would involve circumstances in which the crime had actually been proved against him, would be a stronger case. But the actual public interest involved, I would submit, is not different in the two cases. They're both essentially questions of deterrence.
The assumption I notice in paragraph 54 of UNA, the court itself actually speaks of their task of maintaining public order. It's on that basis that they expel an alien convicted of criminal offences. I mean, I don't quite know how that slots into 8.2.
Yes.
Because
my Lord,
the only relevant clause there would appear to be the prevention of disorder or crime.
yes, well, even if you read public order literally, it would fall within that rubric, prevention of disorder or crime, although I would, in response to your Lordship's question, make the point that a lot of these paragraphs and references to the public order are actually translations of the French legal concept ordre public, which is not concerned with public order in the sense of safety in the streets. It is very much more, it's much closer to the concept of the public interest, as we would express it in legal terms here.
But isn't the sort of underlying principle under which you expel those who are being convicted, those aliens convicted of serious crime in your country, and I imagine it's exactly the same in this country.
It is.
I mean, it's not part of the punishment.
No.
It is, in fact, in order to stop them committing further offences here in future.
That is true, although it does also have a deterrent effect, or is thought to.
Yes.
We'll adjourn until 2 o'clock.